The law terms admissible and inadmissible are used to describe evidence and how it relates to a court proceeding. Admissible evidence is fair evidence or relevant to the facts of the case. On the other hand, inadmissible evidence is information that doesn't portray accurate evidence to a specific case. It could also sway the jury emotionally and not factually, as well as it could be misleading or not be based on recognized science. It may be testimony from somebody who did not witness the crime. Evidence could range from a witness's testimony to demonstrative evidence such as physical objects, photographs, plats, drawings, things that the jury may hold and feel. The evidence is evaluated to determine whether or not it could be used in court. If it's a jury trial, the judge is the gatekeeper of what evidence is admissible or inadmissible. Any jurisdiction like Maryland, D.C., and Virginia are going to have a host of rules about what's admissible and what's not admissible. Sometimes these arguments are presented to the court ahead of the trial in the form of a motion in limine, and the court will rule on what's admissible before the trial begins. Other times, these arguments may be raised on the fly during the trial, and there might be argument heard outside of the earshot of the jury about what evidence is admissible that the jury may be presented with. If one party objects to evidence, the judge will review the evidence, hear the arguments about the basis for why it's admissible or the opposing party's arguments for why it's inadmissible, and then make a ruling. If a piece of proof is deemed inadmissible, then it cannot be entered into the record as evidence, and it can't be used against the other party. It can't be referenced in closing arguments, and it can't be relied upon. During the trial, it's important for the lawyer to make the record. In other words, if there's evidence that was not deemed admissible by the judge and not presented to the jury, the lawyer must put his arguments on the record in case he later appeals the issue. This is why it's crucial to gather as much proof in the beginning and to have your lawyer look at what's relevant to your specific case.